I just want to mention real quick. Also, anything that is said today should not be considered as a legal advice. If you have any questions at all, be sure to contact your association counsel. So, Courtney, well done. Thank you for having us. We truly appreciate you. And now let's turn it over to Jeffrey Rembaum and Alan Schwartzeid from Kaye Bender Rembaum. Take it away, guys.
Thanks. Good morning, everybody. Good morning, Alan, Courtney, Jeff, everybody out there in Zoom webinar land. I'm going to start today's presentation a little different and apologize before we get started because you guys are going to have so many questions and we hope to answer them. Problem is, we have so much material. You can thank the Florida legislature for that. So we have to get through this material first. Alan and I are going to do our best to do it. It's going to go fast. You'll want to take notes. If you want to follow our presentation, you can actually download all of this. Many of you know about Rembaum's Association Roundup, Community Association News you can use. I went ahead and put all this legislation together in a 2024 legislative guide. It's on behalf of Kaye Bender Rembaum. It is absolutely free. You can download your copy. So if you don't catch everything today, or even if you do, go ahead and download this presentation. It will be useful to you in the future. It is completely free. So we know some of you out there, some of you know us, some of you we don't know, and you don't know us. So Kaye Bender Rembaum, we are a community association law firm. We represent about 1,400 associations in the state of Florida. We're in Pompano Beach, Palm Beach Gardens, Tampa, and Alan is our rising superstar running our Orlando office for us, and we are so blessed to have him. Congratulations, Alan, on being board certified. Absolutely fantastic, and good morning to you.
Thanks, Jeff. Morning.
Welcome. What else to tell you all about? We have all kinds of free seminars and webinars that we offer. So just stay in tune with kbrlegal.com. That's where you're going to go to download the legislative update, www.kbrlegal.com, and you can download your own copy. We believe in education. We have radio shows that we regularly do as well. My partner, Peter Mullengard and Robert Kay. Alan Schwartzeid is often on the radio as well. What else can I tell you guys? I think we should probably jump into it. Did I miss anything, Alan?
Yeah, you forgot to mention that if they're not happy with their counsel or if they need counsel, they should probably reach out to me or you or one of our other attorneys.
I like it. I like it. But if you're happy with your legal counsel, then just stay where you are. But if you are looking for a change, think of us. Also, if you're happy with your manager, stay there. But if you're looking for a new manager, GRS has really come a long way. They are absolutely fantastic. They've been in this community in and around the state of Florida for such a long time, since 1989. They have very experienced long-term managers. And you really want that type of continuity with a management company. And they have great systems in-house. They're absolutely, if you're considering a new management company, give them a shot. Okay, enough about that right now. Let's talk about what we're going to talk about this morning. There's so much. We've got House Bill 1203, House Bill 1021, all that big legislation affecting condominium and homeowner associations. Alan and I are going to go back and forth on this a little bit. We're going to start. I pulled out all the information about the new management requirements from House Bills 1203, 1021, and a new one that came in that's kind of weird, House Bill 382. We'll talk about that in a few minutes. We'll talk about House Bill 59, House Bill 293, a new hurricane protection statute for homeowner associations. We'll talk about House Bill 215, which is the $30 million Florida condominium pilot program, which they haven't even begun yet, how to promulgate the forms. And we'll talk about that when we get there and how you can apply for it and all that good stuff. Then House Bill 1021. And finally, your favorite and mine, if the state government wasn't enough putting all this new material out there, now we have to comply with the Federal Corporate Transparency Act too. Oh my gosh, where does it actually end? We know where it starts. They just love to tinker every year with our statutes. Why can't they just leave them alone? I don't know. Why can't they have parity between the condo and the HOA statutes? You know, maybe one day we'll get there. We certainly try as community association lawyers to guide them in that direction, but all we can do is guide them. We can't make them drink the water. All we can do is offer it to them. So when it comes to licensed community association managers, these are from House Bill 1203, which is dealing with HOAs, and it's amending Chapter 468. Chapter 468 is different, right? You hear about 718 dealing with condominium associations, 720 dealing with homeowner associations, 719 dealing with cooperatives, but you all out there in Zoom land rarely hear about Chapter 468. And that's a DBPR statute dealing with the licensure of managers. And for the first time, we have all new disclosure requirements set out in that act. And we're going to talk about just a few of them today. Obviously, you can read the minute detail in the download. So be sure to go to kbrlegal.com while I'm talking and grab your download so you can follow along with us today. And for those of you that do, we're actually starting on page 2 of the outline, dealing with Chapter 468. So a community association manager has to attend at least one meeting annually. Makes you wonder where that comes from, right? What manager doesn't attend at least one meeting annually? However, new requirement for the manager, really interesting. It's as though the manager is now your community college professor or your high school teacher. And you walk by the door, and on the door is posted what their duties are, what class they teach, and what hours they're available. Well, managers now have to provide contact information to the membership, if you will, the name of the contact person, their hours of availability, provide also what their general duties are. And if that changes, they have to let the community know within 14 days. So management companies, if you're taking Alice off the community and assigning John or vice versa, you need to let the community know that. You have to post all this information on the website of the community association as well. And remember, within 14 days of any changes, community must be made aware. Important, if a member makes a request to see the community association management contract, and they don't do an official record request, but they give that request to the manager or someone in the management company, there's now a mechanism to obtain that document without having to do the official record request. Now it's in Chapter 468, and it basically says if someone makes a request for that contract, you got to give it to them. So simple and easy to comply with. Now, turning our attention ever so slightly to House Bill 1021, which is the Condominium Act, right? Oh, sorry. Yeah, House Bill 1021 deals with the Condominium Act. And it too is amending Chapter 468, dealing with community association managers. God forbid the legislature just did a bill regarding community association managers instead of polka dotting it everywhere, and when we had to go extract it all. In any event, CAMs have to return records. Many of you have been through the change in management, and it's been a pain to get records for one reason or another. Now they are statutorily required to give those records up within 20 days, with certain exceptions we're not going to go into this morning. There's also a term you need to be aware of, the third degree of consanguinity. Legislature loves to, and lawyers and judges use terms to keep everybody out. What the heck is consanguinity? I think we all had to look it up when they first started using it, except for a very bright legal eagle in my office who knew right off the top of her head. Of course, everybody knows what it means. 3 degrees of relationship. So a grandson, the father, and the grandfather. That's the easy way to think about it. Doesn't have to be blood relation. It has to be a familial relation. So in the family. So it includes adopted and all of that. And if the manager essentially has any relationship within the third degree of consanguinity for selling goods or services to the association, then there are strict disclosure requirements. So the manager's, I'll make it easy, the manager's father or mother's involved in a company and they're selling Dixie cups to the association, well, that's disclosable by the manager. And if not, the contract, pending on the circumstances, is either going to be void or voidable by the board, by the membership, etc. There's also bidding requirements now for managers when they're bidding on, if again, they're selling a service or product and it's beyond $2,500, there's additional requirements there. Not going into much more detail on that right now, because this is not a course for managers. It's a course for you guys on what affects you most, HOA and condo legislation. There is, I will finish this up, on Senate Bill 382. You're going to have to scratch your head on this one, because essentially managers who have had their license for 10 years, have no active dings on their license, well, they don't have to take CEU credits anymore. Can you imagine that with all the changes this year, wait till you see them, how many total pages? 38 pages. of legislative changes just affecting condos, HOAs. It's not even the full legislative update, folks. This is only dealing with a very small part of what will be our new legislative update once we get a better understanding of all the different laws DBPR is going to want us to talk about in our legal presentations, dealing with easements and other interests in real estate and all kinds of interesting things. But now, if you're 10 years a manager, no dings, you don't have to have your continuing education credits anymore. Makes me wonder, I think, Alan, there must be a legislator who has to have their CEU credits who wanted to exempt themselves because they know they're retiring, because this law is only good, oddly enough, for 18 months. So in 18 months, sorry, managers, you got to wake up and start doing your credits again, but it looks like you have relief for 18 months. But I will say that it's my own personal opinion. If you actually don't still fulfill the requirements, even though you don't need the credits, you're doing yourself a real disservice for any managers that may be out there. Alan, is that about it? I'm supposed to turn it over to you now, right? On
That's
post
it on your-
HOAs. Take it away.
Yep. So just to briefly add to what you mentioned, when it talks about providing the management contract, I think it's important to the association because it's not clear in the statute whether the association or the management firm is responsible if that record is not turned over. Presumably, it's going to be the management firm, but I didn't see anything in the statute that specifies whether there's any liability for the association. So I know if you're working with GRS, you won't have a problem. Like you mentioned, Jeff, it's wholly reasonable to say, okay, you're asking for the contract. The CAM keeps a copy and says, here you go, just like I keep a copy of the legislative guide that we're working on today on my desktop. It's not difficult, but I think it's important to note it's not entirely clear yet who's going to be held responsible or whether there will be any liability for the association if the manager doesn't do what they're supposed to do. Again, you're working with most management firms. This is going to be taken care of and won't be an issue.
Alan, I'll go out on a limb on that one. If someone made a request to the manager for the contract and the manager doesn't comply, not the official record request, but doing it under 468, right. I think that would be a complaint to the DBPR regarding the manager's duties, but I don't think that's going to swing back to the association itself, only because it's sitting in Chapter 468. But as you said, time will tell.
Yeah, I agree. I just, wanted to throw it out there. The other thing, when you talk about management providing goods and services, I generally see this because we didn't really give an example. Where I see this is not necessarily the manager that's doing tasks directly for the association. It's usually where, let's say, for example, the management firm also happens to provide property management services for rentals within the community, things like that. That's where in practice, I've seen this pop up, or, they're providing direct services to the members, even though the manager or the on-site person is technically supposed to be working for the association. So just wanted to throw that out there. Let's go ahead and get into the material that's actually supposed to be mine now. So Jeff mentioned that I'm working on the HOA stuff that the legislature has done for and to us. First off is House Bill 1203. It's changes to Chapter 720, which, unlike what Jeff mentioned with the DBPR law, this is specific to HOAs. So if you're in condo land, you're in a co-op, ignore this for about maybe 5 minutes because this isn't going to apply to you. First thing that the legislature did was define fiduciary duty a little better. This is actually not in 720. It's Chapter 617, which is the not-for-profit statute. It's better defined. The definition hasn't really changed. This is what we've always known it to be. It's still the same standard. The good news is, even though this is the highest duty imposed by Florida law, Jeff, shut your ears for just a second, it's dealt with by the dumbest person in the room standard. What I mean by that is I told you shut your ears. It's dealt with by what a reasonably prudent person would
to me, that's not the dumbest standard, though. That to me is not the dumbest person in the room. That to me is the most reasonable person in the room. If you're totally dumb, it's not going to be an excuse to not exercise your fiduciary duty. Yes, this is what Alan and I do all day during lunch when we're together. We talk about these things, and you'll get to seeing it live in the process. Sometimes we agree, sometimes we don't. But I think if you're the dumbest person in the room and you don't exercise reasonable business judgment, no good. You've got to at least be reasonably prudent.
Right. You have to reasonably believe that what you are doing is in the best interest of the association. That's the actual standard. But, you know, dumbest in the room, we promised a little bit of entertainment, so there it is. Going with the association powers and duties and a bunch of other things, we get into official records of an HOA. These need to be maintained for at least 7 years. And this is, I don't recall whether it's a change or not, but it is now clear unless the governing documents require a longer time frame. So if your governing documents say you need to keep all these records indefinitely or a specific category of records indefinitely, that is now your obligation under Florida law. So what you're going to want to do, make sure that you're keeping them as long as possible. If you are going to destroy them or get rid of them after 7 years, please make sure you have a written policy governing exactly how and when you're going to do that, instead of just saying, well, they're 7 years old, they're going in the garbage. It doesn't necessarily work that way. An HOA, another thing about websites, getting into this important topic. We've never had HOA websites as mandatory before. Effective on January 1st of next year, so you've got about 6 months to make this happen. Any HOA that has 100 parcels or more, now keep in mind that means 100 is included, it's not more than 100, is going to have a website, and it's going to have to do certain things on that website. One of the things is going to be what Jeff mentioned, the manager's information and the teacher's information, so to speak, that Jeff mentioned is going to have to be on that website. You're going to need login credentials for any member who requests them. You need to include privacy and security features. What does this mean? You're not going to have John Smith go on GoDaddy and create a website for you. You're going to have your manager do it if they're offering that service, or you're going to hire someone specifically to create that website and host it separately.
Hey, Courtney, real quick, Alan, Courtney, is GRS all set up and ready to go to offer those website services to its associations?
Yes, we are. Actually, somebody just asked in the chat, do our GRS portals suffice as a website for our community? Yes, they do. So
that's why I put it out there for you.
Go. We are already doing it for the condo associations, 150 units or more. So we are ready and prepared for the HOAs, 100 units or more.
And soon it'll be 25 for you, Courtney, on condos.
Yep, 25.
Talk about that in a few, right?
In 2026. Right. Pretty much everybody that we manage is going to have a website, and we are prepared.
All right.
Glad to hear you're prepared for that onslaught. So there is certain information that needs to be protected. It shouldn't be on the website. And frankly, it's everything that if the association were to receive an official records request, you wouldn't be producing. That's the simple way of saying it.
Well done.
I would say 75% or more of what you normally would produce is going to have to be on that website behind those login credentials. Now, when I say behind the login credentials, in reality, your governing documents, there's no reason to require people to log in to get that information. It might burden your manager a bit less with those requests if you put that up there, not behind the login. The reason I say that is it's already public record. All these documents are recorded unless we're talking about rules and regulations that haven't been recorded, but your articles, bylaws, declaration, that stuff's all in the public record. There's no reason you need to hide it. All of your member meetings and your board meetings will also need to be posted on that website. So when you send that notice out, if you're required to have one of these websites, you're going to be required to post the agenda on here at least 14 days before the meeting. It needs to be in plain view on the homepage, or you need to have a separate page that's specifically labeled as notices. You also need to post anything that's considered to be voted on at the meeting at least 7 days before that meeting if we're talking about a member meeting. Different for board meetings. You would post that at least 48 hours beforehand and put it on the website just like you would if you were posting an agenda and posting it in the community in a conspicuous location. You do need to adopt written rules governing the method or policy by which the official records are retained. What that means is what I mentioned earlier, you should already be doing if you're planning on getting rid of anything. This is also going to include how you're retaining them. Where are you storing them? Are you keeping them electronically or in boxes somewhere? What are you doing with your records, and what are you going to do when you get rid of them? So I've always said there are several policies that every community association should have. This is one you need to have in accordance with Florida law effective July 1st. Moving on to law enforcement subpoenas. If you get a subpoena that isn't just part of random civil action. It's specifically issued by a law enforcement agency or to assist a law enforcement agency. What do I mean by that? It's in a criminal case. Okay, that's the easy way of putting it. There may be civil ramifications that I haven't thought about before, but bottom line, if it's to assist a law enforcement agency, you have to produce whatever they're asking for within 5 business days after you receive it. So if there's a later date on the subpoena, you might be okay, but I would suggest you make sure you get those records, whatever they're asking for, to this law enforcement agency within 5 business days to make sure that you're not in violation of this statute. We move on to financial reporting. And again, this is HOA specific. We have not yet moved on to the condos and co-ops. We've had some financial reporting requirements. They were based on the dollars that you've been bringing into your community throughout the year based on your budget and what you expect to have. This is a new one that says if you have at least 1,000 parcels, 1,000 lots in your HOA, you must prepare an audited financial statement regardless of those dollars. So it used to be if you were bringing in 500 or more than $500,000 or more than, I'm sorry, 500,000 or more, you had to have an audit done. Right now, it's also, in addition to that 500,000 figure, if you have 1,000 parcels, you got to do it. Okay. Now, there used to be where if you were voting as a majority of the members to say, we don't want to do the audit, it's going to be too costly. We just did one last year, and there's no reason for us to spend that money. Well, it used to be that you could do that for, let's say, 2 years. Now it's a new vote of the members every year to avoid the audit, whether that's for, the 1,000 lots or for the 500,000. Now, the important thing to note is I mentioned the audit. This is for reducing any level that you have to have a vote every year by the members. Okay, moving on to debit cards. This has been the deal in condo land, and as Jeff mentioned, it would be much easier for people like us to figure out what the heck we're supposed to do with legislation if condo matched HOA. Well, this is one where the legislation brought the HOA world a bit closer to condo land. You basically can't use a debit card for anything other than what is an approved association expense. If you do use it for another purpose, and it's not what's labeled in the statute as a lawful obligation of the association, that's considered theft and is punished under criminal statutes. So in other words, if you are using a debit card for the association for non-association purposes, you're in trouble. And it's not just, well, you might be off the board, it's an actual crime. In other words, get a credit card instead of using the debit card constantly. I've been saying this since the debit card thing came around for condos about 5 or 6 years ago. Anyway, financial accounting, an owner can request a detailed accounting of any amounts they owe, and the association has to provide that within 15 business days after the receipt is after the written request is received. What does this mean? An owner owes assessments, an owner owes fines, an owner owes any other charge to the association. They request an accounting, meaning what is the initial charge? What's the interest? What's the late fees? Do I have attorney's fees and costs that I now owe on this amount? You have to produce it within 15 business days. If you don't, then if it's a fine, it's completely wiped out. Okay. This is at least clear enough to say that only fines are wiped out. I suspect that people are going to intentionally misread it to say, you didn't provide a payoff for my assessments within 15 business days. I don't owe anything anymore. And our response is, sorry, but you're 100% wrong. You still owe the money, now pay it. Or we'll foreclose, up to you. Moving forward, board member certification. This is a nice big mess that we hope to be cleaned up very soon. But bottom line, I think it's an excellent idea. Jeff, I know you were a proponent of this, and I always have been as well, that board members need to actually...
Oh, no, don't blame me for them taking a 4-hour class.
I'm not blaming you for the 4 hours. You've got to give me a chance to clarify, Jeff. You were a proponent of board members being educated. What neither of us proposed or recommended or think is a good idea is a 4-hour board certification class. I'm miserable after 2 hours, and I'm teaching these. I cannot imagine having to sit through and listening to me for 2 hours. So what this requires is a 4-hour class when you are first elected. Right now, all you needed to do was sign a piece of paper that doesn't really mean anything, but is called a certificate, or you had to take a class, which we were teaching for about 2.5 hours. Now you're going to have to take a 4-hour class that, although it's apparently required, I need more coffee. I'm sorry, guys. Although it's apparently required already, DBPR hasn't told us what the heck they want us to actually teach and hasn't authorized anyone to actually teach the class. So
excuse me, we got our 4-hour class approved just the other day. We did. We
That's
turned in our
fantastic.
subjects and they came back with approval. Now we got to put it all together.
All right. Well, I'm sure Jeff and I and several others within the firm will be working on putting that out as soon as possible and presenting it maybe next month, possibly. I won't say sooner because that's unlikely in my opinion, but maybe in August. That's great. Thanks for the heads up, Jeff. I didn't even realize. So bottom line, it's going to be a 4-hour course. There are going to be additional educational requirements depending on the size of your community. One is if you have less than 2,500 lots, you need at least 4 hours of additional credits every year. If you have at least 2,500 lots, you'll need 8 hours of continuing education every year. And this 4-hour course is going to be something that you need to take within that first 90 days instead of signing a piece of paper or taking the class, which is what was required before July 1st. Now, the association has to retain this certificate once the class is done for all the newly elected directors for 5 years. My opinion is keep that for as long as they're serving so that you're not left in a situation where, well, I took it 6 years ago and the association threw it away, so now we can't prove that I took the class. Failure to have that, just like it was before, is not going to kill anything that you guys have done based on solely the fact that that record is not in the official records of the association. And Jeff, I don't see it in here, but I believe in an HOA, that certificate is good for 7 years. Is that accurate?
Right. Yeah, it is in the outline. But
I'm sorry I missed it. All right. Well, so if
it's retention, yeah. Anyway, we'll come back to that.
Okay, perfect. All right. Kickbacks. I don't think we need to go too into detail. This is another condo conversion to HOA.
The certificate, I want to clarify, I'm going to interrupt you. Yeah. The certificate is good for up to 4 years.
4 years, I'm sorry.
HOA board member certificate is good for up to 4 years. However, and I'll cover this in a few minutes, the official record retention in the statute for that certificate is 5 years. But of course, the statute says all the records are supposed to be for 7 years. So you can really just drive yourself crazy when you think about all the way they've mismanaged our legislation. But back to you.
And I apologize. That's why my head bounces around so much when I'm trying to remember all of these numbers and timelines.
Alan, and also somebody had asked us, if you're already certified, right? You're already on the board and you're already certified. Do I have to recertify? And the answer to that question is no, you do not. You're already in. But if you haven't certified yet before July 1st, 2024, then you're going to have to certify. And remember, the certification for an HOA board member is good for 4 years. It's different for condo. We'll cover that soon. And remember, you need to retain that record for 5 years. Whew.
So to your point, Jeff, my question then becomes, you've got your initial certification. Does the 4 or 8 credits per year start this year or next year?
This year.
That's what I thought. Okay. So back to kickbacks. You know what? Bottom line.
Wait, Alan. So your point is if you're already certified, you need to go ahead and take your 4 hours and get your 4-hour credit. If you're not certified, then you're going to end up taking the 4-hour board course. And the unanswered question is, if you have to take the 4-hour board course, will that count for your 4 hours of continuing education credit you're required for? And time will tell on that.
Jeff, I'm so shocked that you picked up on exactly what I was getting at. All right, thank you. So kickbacks, don't do it. I don't know how I can say more than that or say it more clearly. You're still allowed to accept your $25 worth of food and drink at a business meeting. You're still allowed to accept goods received in connection with educational programs like this or trade fairs. So for example, if you're at the Condo HOA Expo and you accept our little pen and pad and stress ball, that's okay. You're not going to get kicked off the board or accused of accepting well, let me clarify. You might get accused, but it'll be BS. You won't get in trouble for accepting kickbacks if you're accepting things like that. But if you're accepting it outside of any education program or trade fair, it's a big no-no. it's a felony of a third degree, regardless of the value of that item. So bottom line, don't accept anything in exchange for contracting for services or goods with anyone on behalf of the association. That's a pretty easy thing to avoid, in my opinion. A director or officer charged by information or indictment, meaning a criminal charge with any of certain crimes, needs to be removed from office, and there is a vacancy, meaning they're off, period. It's not just a suspension. Forgery of ballot envelopes, theft or embezzlement of association funds, destroying or refusing to allow inspection of official records in furtherance of a crime, obstruction of justice, which is kind of the same thing, or any criminal violation under Chapter 720. Any of these things will get you kicked off the board. Now,
And these come, I just want to explain to everybody where that comes from. There's a very large, the oldest and largest homeowners association in the state of Florida is down south in the Miami-Dade area. It's called Hammocks. So far, they have discovered $2.5 million, and it's growing. But so far, $2.5 million has been embezzled from this association's funds. Like I said, it's almost a city unto itself. And a legislature ran on a platform of trying to crack down. So they had a lot of draconian laws, if you will, to-be laws, language in some of these HOA bills that did finally get removed. It's as though they were punishing the entire state of Florida for the bad acts of one HOA. I did some research for a Florida bar presentation a year or so ago, and I took a really hard look at the state of Florida and all of the prior embezzlement type situations. And I found about 14 or 15 in the last 7 or 8 years. When you consider the amount of associations we have, it's just not that prevalent. I think in the end, thank God, they took out some of the more draconian parts of that legislation, and they balanced it out and made their point to be heard loud and clear.
Yeah, this is not uncommon to see purely reactionary laws kick in after we see a large incident like this happen one time. Think about the legislation that came out of the Surfside building collapse. Some people say it's necessary. Some say it's absolutely unnecessary. Some people say it doesn't resolve the problem that it was intended to fix. But we all know that the legislature is not going to back out of it now because they've invested so much into pushing this agenda. So that's what we end up with. Hopefully all of this stuff will be cleaned up and fixed so that it's easier for us to guide our clients through what they're actually supposed to be doing. But Jeff, I think you're up for architectural control covenants.
Sounds good. Before I get there, I don't know that we covered the new posting requirements on the website. So I made myself a little star on that. Bottom of page 9 for those of you that are listening out there. So when you have the website requirement and you have a members meeting, 14-day notice, you have to post it on the website. Well, then within 7 days prior to the meeting, you then have to put up any contracts or documents to be voted on by the membership. And as to board meetings, we have a new requirement when you're required to have the website and you're posting your board meeting notice, you're supposed to post on the website the materials, if you will, that the board is going to be considering. That's probably the easiest way to think of it. Notice of any board meeting, the agenda, and any other document required for such meeting, which must be posted on the website no later than the date of the notice. And also, Alan and I are using the word website because we have not seen any HOA app. We are aware they are out there. And you could substitute the word website for app if your community chooses to go in that direction.
Yeah, I've literally seen.
I'm now supposed to talk about. Sorry?
I said I've literally seen one app that I'm aware of for an HOA.
Nice. All right, so I get to talk about some fun subjects that's driving everybody in the state crazy because Joe, who lives in an HOA that doesn't allow trucks on July 1st, went out and in their documents it says no trucks allowed. And he goes out and buys a beautiful Ford F-150 truck, drives it in and says, the law says I can have it. Sorry, Joe, you're in for a world of hurt. Going to explain. But before I can even jump into it, we have to talk about a legal concept called Kaufman language. Lawyers love to use terms that come from different cases that have been decided long ago. One of the litigants in a case was Kaufman. I'm not going to discuss the case except to tell you what it means. In general, we have constitutional, state and federal protections against the government's interference in our existing substantive contract rights. The Declaration is a contract. We call it a declaration, but oftentimes you could just call it a contract. And it's a contract between the association, corporation, the association, and the owner. The government can't come in and make changes to the substantive provisions. Now, when the laws change procedurally, well, that applies to all of us. When it strikes at the heart of the deal, that doesn't apply unless you have Kaufman language. Kaufman language is as amended from time to time, but let's put it in context. This declaration is subject to Chapter 720, as it is amended from time to time. If you have that language in your declaration, then all the new laws apply, and you don't have to do this analysis. Otherwise, you're going to have to talk to your association's lawyer, and ultimately, it's a board decision because these decisions are not without risk. We don't have opinions from a district court of appeal on these issues yet. So Joe that just went out and bought that new truck says, I'm not taking that laying down. You can't tell me to get rid of my truck, even though the declaration clearly says in 20-point letters, no pickup trucks allowed, and says the law says I can do it. Well, there are some basic concepts that lawyers know that general public sometimes doesn't. One is the application of Kaufman language. Another one is that legislation is not retroactive in any way, shape, or form unless the legislation itself says it's either clarifying existing law or is retroactive. So you've got to take all this into account. So therefore, that was a lot. All right, so that's Kaufman language. Do you have it in your declaration? By a show of hands, how many of you have Kaufman language in your declaration? Well, since I see no hands, I know you haven't looked yet. Your homework is to go home, open up the covenants, and read. Usually it's in the first couple of pages. This declaration is subject to Chapter 720, or is subject to Chapter 720 as amended from time to time. If you have that magic language at the end, all these new laws apply, and Joe can have his pickup truck. If you don't, it is our opinion Joe cannot have his pickup truck for reasons I can't explain. A different legal mind may feel differently. I think they would be wrong, but that's, to each his own opinion. But this is what you pay us for. I've been doing this for 25 years now, board certified. In fact, 10 of the lawyers, 10 of our 20 are board certified experts in this field. This is all we do day in and day out. All of us is community association law. So we really come to it from a high level. So let's talk about these new architectural control covenants. And let's start with the notion of an existing premise, because so many associations don't do this or they get it wrong. And I want you HOAs to do this right. Your HOA architectural meetings are required to be noticed just like board meetings. So if Joe wants to paint the house pink and you say no, committee never met, committee never noticed, decided by email, he's going to have his right to paint the house pink because you did it wrong. You're supposed to do a 48-hour meeting notice for your architectural committee meetings and take minutes. Not a problem if you're going to say yes, as much as it is when you say no. The other interesting thing that happens is law came out a few years ago that says to the extent you have not adopted language that deals with the location, size, type, and appearance of different architectural changes, then you cannot regulate it. So if you've never adopted a pink palette and Joe wants to paint the house pink, Joe can paint the house pink because you haven't said what standards are actually available. There is a way around this. It has not been tested in the courts. It's language I came up with. Talk about it with your lawyer next time you're amending your documents. If you don't have this language in your declaration or in your rules, very simply put, to the extent a member makes a request for an architectural change and we have not adopted a standard on that request, then the existing condition of the community is the standard. We have no pink houses in the community. Joe wants to paint the house pink. We now have a standard based on that language. We can honestly say now with straight face, Joe, you're sorry, you can't paint your house pink. Again, that language has not wound its way through the courts yet, but I think you got a pretty good chance. Nothing is certain in life, but it seems like that would comply with the legislation. We have new prohibitions. An association, architectural, construction improvement, or other similar committee of an association may not enforce a covenant or a rule or guideline that limits or places the requirements on the interior of the structure, not visible from the front, the adjacent parcel, the adjacent common area with a community golf course. I can live with that one. We pretty much don't regulate what we cannot see inside of the HOA homes. It makes me wonder where that one actually came from. Interestingly, as I'm thinking about that one, how will that interfere with someone who wants to run a business in their association? You also at the HOA cannot require review and approval of plans and specifications for certain utilities when you already have those utilities in your community, when that utility cannot be seen from, you guessed it, the parcel front, the adjacent parcel, the adjacent common area, and the community golf course. When you deny an ARC request, you have to now deny with specificity, or your denial is not going to be valid. So you have to cite chapter and verse. No, you cannot paint your house pink because section 3.2 of our rules and regulations provides the applicable colors, and pink is not one of them. You don't do that, then your denial is subject to challenge. Here's the one that everybody is talking about. Regardless of any covenant, restriction, bylaw, rule, requirement of an association, and unless prohibited by general law or local ordinance, an association may not restrict parcel owners or their tenants from installing, displaying, storing any items on the parcel not visible from, here we go, the front, the adjacent parcel, the adjacent common area, community golf course, including but not limited to, oh boy, boats, flags, artificial turf, vegetable gardens, clotheslines, and RVs. Well, no Kaufman language. Now you guys are all experts out there in Zoom land. You understand the concept, how it works. If you have Kaufman language, well, that law is going to apply. If you don't have Kaufman language, then it doesn't apply. So again, board members, whenever I explain this to our clients, I always push it back to the board to say, ultimately, guys, this is our opinion. I've looked at your declaration. You don't have Kaufman language. As far as I'm concerned, this language does not apply to your community association. What do you want to do? Because remember, the board is the decision maker for the community, not the lawyer, not the manager. It is the board that makes the final decisions. Garbage cans. Now, these, all right, everything we talked about pretty much were substantive changes. It's questionable whether these next two items are substantive or procedural. Al and I could talk for 5 days on procedural versus substantive and never get to a final answer. But we know, sort of like the Supreme Court's definition of obscenity, well, we can't define it, but we know it when we see it. So here we have a law that says you cannot fine somebody for bringing in their garbage cans 24 hours past the deadline. Did that strike at the heart of the deal, or did that make it more inconvenient? So to me, I kind of lean towards procedural on that one. Holiday decorations, they have to be removed by a particular time pursuant to the covenants, the rules. Well, this new law says, members, you get an extra week. I don't think it's worth the legal fight to fight either of those two particular provisions.
Jeff, if you don't mind me jumping in for just a second, I do have a problem with this garbage can thing. Because let's say, for example, you've got a community that has trash collected twice a week. Now, I know that's becoming increasingly infrequent, but if you've got someone that collects trash twice a week and you can't do anything about the fact that it's left out 24 hours before or after both of those days, you're literally now having the legislature tell us that we need to allow people to leave their trash cans out literally a majority of the time. I think that's absurd, and it does get into the heart of what you want to have. As
maybe it is substantive then to that community, but procedural to others. I think it can go, you can look at it.
Like you said, I think it depends on the circumstances. I know it when I see it. I'm agreeing with you, but I think in some communities, this just goes above and beyond what the legislature can do or not do based on substantive versus procedural. Sorry to interrupt. I just thought that's an important distinction. Because
anytime. I'm winning the over-under today on attendees, so interrupt away. Okay, moving on. Pickup trucks. Governing documents cannot prohibit an owner, tenant, guest, invitee, property owner from parking his or her personal vehicle, including a pickup truck, on their driveway or any other area. I think I've covered this one ad nauseum already. No, you don't. If you don't have Kaufman language, as amended from time to time, that law, in our opinion, does not apply. Work vehicles. Here, sometimes communities have rules saying you cannot have commercial type lettering or, advertising your business on your car. This legislation is saying, yes, you can. Well, Alan and I are saying, in our opinion, no, you can't unless you have Kaufman language. You cannot prohibit any vehicle that is not a quote unquote commercial vehicle. Legislation loves to refer to other legislation and never tell you what it means. That's why you need to download our update, our 2024 legislative guide. If you haven't, then go ahead and do it now at kbrlegal.com, because on page 15, I give you the definition of what the legislature says is a commercial vehicle, which essentially you're looking at a gross vehicle weight of 26,001 pounds or 3 or more axles. So if it isn't a commercial vehicle, it is allowed in. Wow, talk about a substantive impairment on an existing contract right. That sings it true. Contractors, this one blows my mind, right? The governing documents cannot prohibit an owner from bringing in a contractor who doesn't have a professional contracting license. Wow, I don't want to live next door to the neighbor that has their whole house rewired and replumbed by an unlicensed electrician and unlicensed contractors, man. That's not where you want to be. So I'm really surprised that was put in to the legislation. Grievance and fining committees. Hopefully we covered all that in such a way that everybody understands it. I'll look through the questions in a few minutes. Alan wants to say something.
I do. So my question to you is, what's your opinion on whether or not the association process can require the licensure, require everything else, and say, we're not requiring that they be licensed in order to enter on the property. We're just requesting that documentation. And if you don't provide it and you don't clarify that they're not licensed, well, I'm sorry, but you have an incomplete application.
You can play with that game. You know, you can play that game a little bit, but if they already have a rule that says you need to be a licensed contractor to come in, my opinion is this law doesn't change that. It's just on a go forward basis for a brand new community. If we're taking one out of the ground, we're stuck with these things. We can't. If I'm drafting a whole new declaration, developer comes to me, we're going to build an 800 lot association. Jeff, will you draft the documents? I love those phone calls. Sure, happy to. Boy, we're stuck with all this stuff because there was no existing language. There was no covenant to begin with. So we have to create the documents in conformity with existing law. Remember, the law that's in effect on the date the contract is signed is the law by which that contract is judged. So that's another way to think about Kaufman language. Okay, moving on to fining and grievance committees. A couple of changes here. Some of them are somewhat monumental. Once you've given an owner, right, the board sets the fine, then not less than 14 days, that owner has to get a notice, the violating owner, with at least a 14-day notice saying when the fining hearing committee is going to meet. Well, now there's a requirement that that committee, the fining hearing committee, must meet within 90 days of that time period. All right. So within 90 days of the 14-day letter. If you want to have the fining hearing committee electronically, because everybody's traveling, that's fine. But you also have to let the offending member appear electronically as well. Now, the fining committee met. Within 7 days of the outcome of that committee meeting, you have to inform the parcel owner in writing of the outcome, and also what they can do to cure the violation and when they must pay any fine, which cannot be any sooner than 30 days from the date of the letter. Whoa, from the date the letter is received. Really weird language. How are we supposed to judge when the letter is actually received? So now we have a new problem because we have to now prove when the letter was received. And gosh, I don't know about y'all, but using the United States certified return receipt has been a disaster of late. And I don't know about you, Alan, but I've resorted to using Federal Express, the slowest method possible because of the added expense. But at least I get a time and a date and a pretty picture showing me that it was, in fact, delivered. So those are things I think management company and HOA, because those letters are not going to be sent by us. They're going to be sent by y'all. You're going to have to prove it. Because if you come to us and you want to enforce and you can't show us that that letter was delivered, we're going to have a problem in the courtroom. So we've got to think of all those things in advance. If a violation has been cured before the hearing or the manner specified in the written notice, the fine or the suspension cannot be imposed. Wow. Let me say that again, because we got to talk about this. If a violation has been cured before the hearing or the manner specified in the written notice, the fine or suspension cannot be cured. So, Joe, we have a rule, I'll make it up. You can't leave your car on the street past 12 o'clock at midnight. Joe does. We send him a letter. Is Joe in violation? Can he cure that violation before the hearing committee? Well, it really made me think, and I don't know how this is going to play out in the courts, but essentially, I think we have a category of non-curable violations. If you haven't pressure cleaned your driveway, that's different, right? You can, at any time, you can go pressure clean that driveway before the hearing and do away with the problem. If you cure it before the hearing committee, then no farm, no how. No, I think I just said that backwards, but in any event, what about parking overnight? Because every morning he's going to move the car. Does that mean he's now cured the violation? So I do think we have to think about violations that are non-curable because they're just not curable. If you have to move your car before 12 a.m. and you haven't, well, how can you later move your car after 12 a.m. and cure that violation? That's a violation that I think sticks. We're going to have to fight these out in the courtroom, but there's some good language in the legislation that led me in that direction. You'll need to talk about it with your own lawyer as well. If the violation, right, you've went ahead and the board set the fining committee met, you gave them the 14-day notice, then coming out of the hearing fining committee, you gave them a letter within 7 days, telling him or her that the fine is due, but not sooner than 30 days from the date of delivery of the letter. Attorney's fees and costs cannot begin to accrue until after those 30 days have transpired. That is relatively new in the law. So you need to watch out for that. Let's see. Am I still on, Alan? I think I am. Fraudulent voting activities. Well, we have all kinds of existing text dealing with fraudulent voting activities in the legislation, willfully and falsely swearing, attempting to perpetrate a fraud in the election, preventing a member from voting, menacing, using or threatening to use force, right? All these things. But now we have new criminal penalties. So if you knowingly aid and abet, advise a person in the commission of a fraudulent voting activity, well, now you can be punished for a misdemeanor in the first degree. And the list kind of goes on from there. If you agree to conspire or combine with at least one other person to commit a fraudulent voting activity, then once again, misdemeanor first degree. If you have knowledge of a fraudulent voting activity and lend aid to the offender, then misdemeanor of the first degree. Interest, if you have no language in your declaration, you can charge up to 18%. No, you can't charge compound interest. Electronic voting, great change in the legislation, a good one. In the previous to this, if you wanted to opt into electronic voting, you should have done so with a wet signature, an ink pen. There was no way to officially opt in through email or electronically, and now there is. So now the voting companies you guys all hire to handle the association electronic voting can send an email to the membership saying, do you want to opt in to electronically vote? And they can just push a button and they're off to electronic voting. First responder vehicles. Once again, legislature does a great job of confusing us because they say first responder vehicles, right? An association may not prohibit a first responder who's a parcel owner, tenant, guest, invitee, or parcel owner from parking his or her first responder vehicle in an area where the parcel owner, tenant, guest, invitee can park, including the public roads and rights of way. Last year, this said police officer, police vehicle. Now it says first responder vehicle, but again, they don't give us a good definition of first responder without digging into the statutes. So I did just that for you. And on page 19, you'll see the definition of first responder. And it's essentially a policeman, a fireman, a paramedic, or EMT. It's not their personal vehicle. It is their official vehicle. So there's a big difference between those two. Okay, Alan, pages 20 and 21.
You got it. All right. So briefly back to fining. The alternative to dealing with the fines and not being able to, or dealing with what Jeff mentioned as treating it as uncurable, is going after an injunction for a repeated or ongoing violation. When I draft an enforcement policy, I include a provision that specifies if you violate a certain amount of times within a certain time frame, we're going to treat that as likely to recur and as though it is ongoing. So that might be one way, not necessarily around the new statute, but to deal with the issue rather than be precluded from dealing with it altogether because the owner is basically not given an opportunity to cure. All right, moving into what we're talking about. This is House Bill 59, and it again is HOA only. We haven't gotten into condo land yet. There's a requirement that was created to provide copies of all rules and covenants of the association before October 1st of this year, meaning you've got less than 3 months to do this. It is every rule, the declaration, the articles, the bylaws, your architectural criteria, your policies and procedures. All this needs to be provided to the members before October 1st. Now, the good news is you can house this stuff on your website if you've got one, or behind your portal with GRS, or if your other management company is offering that. You don't necessarily have to mail this 100-page packet out to every one of your members before October 1st. You can provide a notice that all of this stuff is available on the website or in some other location, but you basically have to say, here's where you can find this. Every member of the community is entitled to a copy. That's the simplest way I can say that. Moving on to House Bill 293, you need to adopt hurricane protection specifications for every structure or other improvement on a parcel that's governed by the association. So this is another one I mentioned earlier. I've got 5 or 6 policies I think every community in Florida should have. This is number 2 that you now must have. And I believe this took effect as of May 28th, meaning you're already too late. So get on it now. What this requires is that you include the color and style of hurricane protection products and anything else the board thinks is relevant. There are certain things that you can't prohibit when it comes to hurricane protection. So that's really what we're talking about here is you need to have hurricane protection specifications. I see a lot of people that are just saying, well, we'll just build this into our architectural criteria. That's fine with me. I don't see any reason you can't do it because it is something that the members are probably going to submit and say, this is what we want to do. I think the important factor here is you have to have the specifications and you have to have your attorney take a look at whatever those specifications are to make sure that you're not prohibiting anything that the statute requires you to allow. I think that's it. I think we're moving on to condos finally.
Almost, except I'm going to cover the 3 takeaways.
Here's the real value, folks.
Right, exactly. Your gift for attending this morning's class. Number 1, the official records retention policy. You have to adopt one pursuant to this year's legislation. Do you have one? It could be very simple. It could be our retention policy is that which is set out in Florida statutes. I think you should do something probably a little more detailed than that, but that would qualify. Also, when you do these kind of things, do them by a written resolution and adopt that resolution at a board meeting so it's on a separate 8.5 by 11 piece of paper so it's easy to find for the future. Remember, too, that the legislation says that all the records are 7 years unless otherwise set out in the governing documents, and then the legislation immediately contradicts itself because you have to retain the written certification for 5 years, bids for 1 year in the legislation. So think of those things. You want to have your lawyer help you draft the official record retention policy so you're in compliance. Also, elections, it's not 7 years, it's 1 year. So first they say you have to keep it all for 7 years unless the governing documents say otherwise, and then they do exceptions without telling you there are exceptions. But in any way, my point is you need to adopt your official record retention policy. Then, as Alan just mentioned, you have a deadline to provide that notice or to provide the governing documents by October 1st, 2024. Work with your management companies on that one. And then you're already delinquent if you haven't adopted your hurricane protection standards for every improvement in the community. So you have to adopt those hurricane protection standards. Now, here's what the legislation doesn't tell you in the track and trip for the unwary. You go to a board meeting, you say no, I love to say, I'm using the word pink colors today, but it works. So we can have no pink shutters in our community. You do it at a 48-hour board meeting notice. Well, you've also just adopted a rule regulating what an owner can do on their lot. Whenever you adopt a rule governing what someone does on the lot, it's a 14-day, it's still a board meeting, but it's a 14-day meeting notice board meeting. And that notice has to just not be posted, but it also has to be sent out to all of the members at their official address, whether it's US mail or email, if they've opted into it. So that's a trap for the unwary, because you have to adopt these standards. But if you're adopting the standard regarding the owner's houses, then you need to remember to also comply with that 14-day meeting notice requirement. Quick recap, remember the 7-day posting requirement for membership meetings. If when you post your membership meeting, if there's a vote of the membership and you have a website and they're considering a contract, a document, voting on something, that has to show up on the website at least 7 days in advance. And then if you have a website and you have the board meeting, the other materials should also be posted on the website, the non-privileged materials anyway, at that time. Okay, Alan, I think it's off to you again.
All right, let's do it. So House
Right.
Bill 1029, the My Safe Florida Condo Pilot Program. This is essentially a program that the government created to fund grants for hurricane protection for condos. We're in Florida, so that kind of makes sense to me. It basically provides funds for condominiums to add hurricane mitigation measures, is the language that's used in the program and in the statute. It requires disclosure to the members that the association is asking for these government funds, followed by a board vote and a unanimous vote by the owners of property in the building that's going to be protected. Now, I say the building. I don't mean it's a unanimous vote of the entire condo. This statute is pretty clear. It's only the owners that are in this particular building or structure that's going to be protected. What that means to me, Jeff, you'll correct me if you disagree, but if it's your clubhouse, no one resides there. So you might not need that second member vote to get the authority. You might be able to just submit it. This also is going to require an inspection of the property and a range of the cost estimates that you're seeking the grants for. What work is actually going to be done? It's not just, hey, we want a bunch of money because we want to make our place a little bit safer. It's here's the work that has been suggested to us by a hurricane and damage mitigation specialist, and here's what we plan to do. The funds are available for the inspection itself as well as the work. And it's on the basis of $2 in government funds for every dollar that the association will spend. I don't know that we've gotten all the information we need to really start submitting applications for this yet, but it is something that I'd suggest you start discussing with your attorney, especially if you're in, let's say, an older condo that's closer to the beach, that might really need these funds and is already hurting thanks to all the other stuff we're going to talk about today, from all of the Surfside related legislation that now requires certain new inspections, new reserves, etc. So moving on from that, I see.
I was just going to point out there's about 30 mil in that program. That DBPR has not promulgated forms yet. Last night, Michael Bender was with one of the legislators, and they were talking about this. Maximum amount of money you're going to be able to get is $173,000 on a good day. I don't expect anybody to get that. If you're going to be using any of the money that improves an owner's unit, even though you could only get up to $1,500 for that per unit, it would require the unanimous vote of all of the membership. And again, as Alan explained, DBPR has to promulgate forms to get the money, and there's no forms yet to see. So we're all sort of in a lurch on that. Thanks, Al.
All right, thank you. So moving on to Condo World. Congratulations, guys. You made it. Mandatory structural inspections for condos and co-ops. Until now, milestone inspections didn't apply to certain types of buildings. What a milestone inspection is someone that's able to perform the inspection, going out to the property and visibly seeing, is there a structural defect that we can see? Okay, so that's step one. That's phase one. We're not going to go into detail because frankly, we have less than a half hour left. We've got probably 20 classes we've done on these milestone inspections and structural integrity reserves. So you're welcome to check out one of those. I'm sure that GRS has several as well that they've done. But bottom line, this milestone inspection is no longer required. It was single family, 2-family, 3-family dwellings. It's now also 4-family dwellings with 3 or fewer habitable stories above ground. We've got some new definitions that frankly, I don't think we need to go through right now, but they are in the materials for you that, again, you can get from our website under Rembaum's Roundup. a condominium in a building. This pertains to creation of condos where there are provisions that say there's a condo within a building. Sometimes that's going to be a condo hotel. Sometimes it's going to be partially residential, partially commercial buildings, or it might be within a multiple parcel building. The declaration needs to include a statement now that specifies, and this is more for people like Jeff and I, but just so you're aware, it needs to state whether the unit owner or the association is responsible for hurricane protection measures, the installation, maintenance, repair, or replacement. Okay, so again, we talked about this program for more money for hurricane protection. If the unit owners are responsible for that, I think it's unfortunately going to be less likely that you get that grant money. Although, in my opinion, it should be the other way around so that we're making sure that the members actually have the ability to fund this. But bottom line, the declaration of any new residential or mixed-use condo needs to clarify who's responsible for this. Okay, that's one of the big things that is usually not found in a declaration unless it's fairly recent. We talked about electronic voting. Just like Jeff mentioned, electronic voting can be adopted electronically. That is also going to be an issue that we talk about here. However, it's a different issue. It's if the member opted into electronic voting, that member is entitled to vote electronically at every meeting, every election in a condo or a co-op, or until they actually opt out. So even if the association, for some reason, I can't imagine why you would choose to stop using electronic voting, but you might be obligated under this statute to actually allow it for certain members until they actually opt out. So you would hopefully be promoting, hey, please opt out. Again, I don't know why you would stop using electronic voting, but if you choose not to allow it for certain meetings, which I think is more prevalent than stopping it altogether, you might be required to allow those particular members to vote this way anyway. Moving on to kickbacks, anyone who knowingly solicits an offer or offers to accept a kickback, it is now a felony of the 3rd degree, and they need to be removed from office. There's a vacancy. Keep in mind that felony of the 3rd degree is up to 5 years in prison and monetary penalties of up to $5 grand. Bottom line, don't accept kickbacks. It's been the law for at least the last 6 years. It's not a good idea. Just do what you volunteered to do and treat it as a volunteer position, please. The last thing I want is for one of my clients to have to kick out a board member because they accepted a kickbacks. Once you receive a complaint that the association doesn't have proper insurance or fidelity bonding, the DBPR needs to monitor the association and can issue fines and penalties if you do not start maintaining that proper insurance. What is proper insurance is very poorly defined and is something that I don't know of any lawyer that can figure out what that exactly means beyond saying you need to reach out to your insurance agent and have them kind of make the determination. Unless
I'll jump in on that.
Specify.
I'm going to jump in just a little bit.
Yep.
Thanks. The reasonable standard, right? The board member we talked about, we opened this up with the reasonable business judgment is the standard by which you are judged as a board member. There was a change in Chapter 718 a few years ago that changed that standard in regard to procurement of insurance. And what it says is that the board member must use their best efforts in insuring the condominium. So think about that, right? It's no longer, when you use reasonable business judgment, you might be right, you might be wrong. Did you act reasonably? Best efforts is the highest standard available in law. So when it comes to insurance, that's not in this year's legislation, it was a number of years ago. But just remember, when it comes to insurance, it's not acting reasonably, it's using your best efforts to obtain it. Back to you, Saul.
Good clarification. Okay, official records. Like Jeff mentioned earlier, it used to be that you needed to have a website in a condo if you had 150 or more units. That is now down to 25. So I would say the vast majority of condos will now need to have a website. That doesn't take effect until January of 2026. Fortunately, if you're working with GRS and several other management companies, your manager will be able to do that for you. You should be reaching out to them now because they will be inundated with requests, especially if they also manage HOAs for, bottom line, a lot of work that will go into uploading all of those records that might have been kept in paper boxes for the last 20 years or longer, that now need to be maintained online instead. Now, the good news is if you're working with our office, we're pulling your governing documents as the first step we take in representing any new client. So as to those particular recorded documents, you're definitely going to have a copy of those electronically if you're working with our firm. Many firms do this. I actually will compile them all together, put them in a compiled document and OCR them so they're searchable, bookmarked, etc. But make sure that you're giving your management firm or your service provider enough time to get all this done by January 2025 or 2026, depending whether you're in an HOA or a condo. There's further clarification that email addresses and fax numbers are only accessible to the unit owners if they've actually consented to receive electronic notices that way. That's the position I've taken for a while now, but the statute was clarified to say if it's not being used for official business, it's not an official record of the association, and therefore it's not subject to dissemination, disclosure, however you want to label it. Again, if that personal information that shouldn't be disclosed is disclosed inadvertently by the association, it's kind of a no harm, no foul, that the association's not going to be held responsible. If it's intentionally disclosed, there you might have a problem. The official records now also include all invoices, transaction receipts, or deposit slips to substantiate any expense by the association. It also includes copies of building permits and copies of satisfactory completed board member educational certificates, which makes sense. Now, keep in mind, most of this stuff was already part of the official records based on the catch-all that was already in the statute that said any other record pertaining to association business. But now this is being directly outlined that these are records you must maintain pursuant to the statute. The big change this year, now, please listen to this if you're in a condo and you haven't even listened to anything else, which I don't know why you'd be here otherwise, but please understand the official records now in a condo must be maintained in an organized manner that facilitates inspection. What this means for you is that if you've been saying, here are our boxes, have at it, you're not required to cherry pick individual records still, but you are required to maintain those records in a way that makes them searchable. Now, if records are lost, destroyed, or otherwise unavailable, the obligation to maintain them includes a good faith obligation to try and find them as reasonably possible. So you have to make, just like Jeff mentioned with insurance, a reasonable and meaningful effort to try and locate these records that aren't in the official records. You can now fulfill official records requests electronically. This is one reason I say put all of the records online, whether you have to or not, because all you have to say if you do that is it's in the portal. Have at it. We're done. Unless the owner comes back and says, I don't have a computer, I don't have portal access, in which case you'd say, reach out to the manager so they can provide you the access, or they say, I don't have a way of doing this. That's the only way you might be required to produce the records in another way if you're maintaining them all digitally behind that login credential. The other big change in condo world, you have to actually maintain a checklist of all of your records and say which ones were or were not produced for inspection during that records inspection. My suggestion is create a list of every single document you guys have in your records. And basically, once you're able to say, hey, everything's available on the website, you have an automatic check of everything because you didn't not produce anything. The only concern I have is that you've got a list of items that are not subject to inspection. So just like you've automatically checked off everything that you're producing, you're going to automatically uncheck everything that you're refusing to produce. And you're putting it in categories potentially that your attorney assists you with preparing this document that says these are not subject to inspection, but they exist. All right, moving on. Failing to produce these records willfully, knowingly, and repeatedly is a misdemeanor of the first degree. Repeatedly means 2 or more violations within a 12-month period. In other words, if you are ignoring records inspection requests, you're going to get dinged and it is a misdemeanor. Don't do it. And failing to produce them is a felony if you fail to produce them with the intent of avoiding or escaping detection, arrest, trial, or punishment for a crime. It's a felony of the 3rd degree. While the membership can vote to obtain a lesser financial report, just like in an HOA, it's only good for 1 year when you get that member vote to say, I don't want to do the audit, I want to do a compilation instead. Same deal with debit cards. Don't use them in an HOA or in a condo for any purpose other than payment of association expenses. My recommendation yet again is figure out a way to get a credit card instead so that this statute is not a concern. Now, you still shouldn't be using a credit card, just to be clear, for anything other than association purposes if it is in the association's name. You do not want to mess and commingle your expenses and go out and buy your new video game on an association credit card. That is problematic regardless of whether you pay it back. Moving on to the bylaws. You now need to hold quarterly meetings if you have more than 10 units that, and when I say quarterly, it's at least 4 times a year. The easiest way for many communities to do that is going to be to have it done every quarter. Some communities will say, right, great, we'll knock it out in January, February, March, and April. I don't see any problem with that under the statute. It just says 4 times a year. But during those meetings, you need to give and put the agenda to include an opportunity for members to ask the board questions. The way that I suggest handling this is allowing members to ask questions for every board meeting. But the way that you do it is you allow them to submit the questions in advance of the meeting, pursuant to a written policy governing member participation in meetings. So this way, you're definitely complying as long as you have 4 meetings of the board throughout the course of the year. The right of members to attend these meetings and to speak at the meetings with each designated agenda item includes the right to ask questions relating to reports on the status of construction or repair projects, revenues and expenditures during the fiscal year, and other issues involving the condo. There's still not necessarily an obligation to answer these questions. There is an obligation to allow people to ask them. And again, my suggestion is allow them to ask the questions in writing and choose which ones you are going to respond to in advance of the meeting. If the condo board meeting agenda item relates to the approval of a contract, a copy of that contract needs to be provided with the meeting notice and made available for inspection and copying upon written request from a unit owner. And when I say or, I mean this is the easy way, put it up on your website or through an app. So you can just do it that way. The board certification requirements for board members that we talked about for HOAs are mostly the same, but there are a couple distinctions here. You do need to do additional education. You do need to take the 4-hour board certification course within 90 days after being elected or appointed. The difference in the time frame, the certification, and this is what I was thinking of earlier, I mixed up HOA and condo, is good for 7 years from the date of issuance in a condo, as long as the director serves on the board without interruption. Now, in a condo, you're going to have to take, if you were elected before or appointed before July 1st, you need to comply with these requirements by June 30th. I don't know if we mentioned that. The preliminary class that you'll need to take that Jeff mentioned earlier, we were just approved for and will be teaching shortly. Just like in HOA world, I believe Jeff mentioned, or at least meant, that applies to condos and co-ops as well. And so what that means for practical purposes, get on our mailing list and GRS's mailing list, because I anticipate within the near future, like the next month or two, we'll be teaching those classes so that people that are newly elected or appointed will be able to cover that requirement. Another requirement, developer appointed board member certification, is different. The developer appointed board member can be certified, and that's valid for 7 years, including any interruption to service, so that the developer appointed board member can be appointed to additional project association boards without having to be recertified. In other words, this can apply and it bounces back and forth.
But at the HOAs, no parity, right? I mean, it's crazy. An HOA board member appointed by the developer on an association board has a microsecond break in service and they have to recertify. So
yeah, well, that would be logical to do it differently, Jeff, but that doesn't always happen with our legislature. Hopefully there will be a what we like to call a quick glitch fix at the end of
I think you mean the same, but yeah.
Yeah, so that it's identical, because I think this makes sense. If you've been certified, why have to do it for 20 different communities? It just makes sense to me. Again, we mentioned new continuing education requirements. I don't think we need to go through those. The proof of certification needs to be in the official records. We talked about the timeline. Reserves with an uninhabitable building. This is a new one, and I think it's actually somewhat helpful. If the local building official determines that the entire building is uninhabitable due to natural emergency, the board, upon the approval of the majority of the members, can pause contribution to reserves or reduce reserve funding until the local building official says the condo building is habitable. Any reserve account funds that are held by the association can be extended pursuant to the board's determination to make the building and its structures habitable. In other words, the reserves can be used to make the building safe. If the local building official determines that the condo building is habitable, the association must immediately resume contributing funds to the reserves. Now, Jeff, the question to you is, does this apply to the little g reserves that are mandatory and must be maintained no matter what, regardless of any vote of the members? I think this applies to all reserves. You let me know if you disagree, because this is specifically for safety, and those structural reserves are also for safety of the building and the members.
So what is your point?
My question is, do you think that all statutory reserves, or only the ones that are not structural in nature, are going to be suspended if this determination is made? In other words, we don't have to maintain that because the building's unsafe.
Oh, I think, you're just talking about that one where the building is declared uninhabitable,
Yeah.
blah, 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 blah. I'll deal with it when we have to. It's such a one-off piece of legislation. So if we get a client and God forbid that happens, we'll deal with it, but we'll take the practical approach.
All right, deal. Moving on to structural integrity reserve studies. Within 45 days after receiving that study, the report that you get, the association needs to distribute a copy to each owner or deliver a notice that the completed study is available for inspection and copying, and provide the division with a statement indicating the study was completed and the association provided or made this document available. What you're going to do is, just as I've suggested with all other records, whether it's HOA or condo, if you have the ability to notify everyone that it's available, I don't know how many pages this report's going to be, but I anticipate it's going to be more than 30 or 40. Don't mail that out to everyone. Just mail them a postcard that says, this is available. If you want a copy, it's either behind your login credentials on our website, or you can request a copy at any time. Director and officer offenses, you are guilty until proven innocent. If you are accused by a criminal court with forgery of a ballot envelope or voting certificate, theft or embezzlement, or destruction or refusal to allow inspection or copying of records in furtherance of a potential crime. While the charges are pending, the director or officer is off the board and cannot be appointed or re-elected as a director. Once those charges are done, that no longer applies. But again, it's guilty until proven innocent. We talked about fraudulent voting activities. There's a bunch of them that are punishable now as a misdemeanor of the first degree. Basically, since we have 7 minutes left, I'm not going to go through all of them. I want to leave some time for Jeff to get through what he needs to talk about for the end. And so what we'll say for now with respect to this issue is, don't defraud your members and try and stay on the board of a volunteer association. Or not a volunteer association, to stay in a volunteer position in the association, and risk that you are going to be accused and prosecuted for crimes. Just let it happen. Whatever happens at the election happens. But there's a list, and I'll let you go ahead and look at it on your own within the materials that we've prepared for you. And Jeff, thank you, because frankly, these materials help all of us, including your own attorneys. And I will turn it over, Jeff, on page 32, item number 10, maintenance and hurricane protection. You're on mute, my friend.
All right. That better? Can you hear me now?
Yeah, you're good.
All right. There was a question, something about, let's see if I can find it here. 4 quarterly meetings consecutively, isn't it once per quarter?
Yeah, I thought it said 4 times throughout the year. Perhaps I read the statute
Go ahead,
wrong.
while I'm talking, go ahead and take a quick look back in the notes so we can clarify for everybody. Should be in the materials, should
The
say
notes
that.
do say 4 times a year.
Okay, then we will go back and double check ourselves as well. Okay, I thought it was 4 times a quarter as well. That rings a bell, but here we go. Hurricane shutters. So all the condominium associations had to adopt hurricane shutter standards. Well, that's out the door. You now have to adopt hurricane protection standards. So it's so much broader. Very, very pleased that the legislature went in this direction. You must adopt hurricane protection standards. Again, I would suggest you do this by way of written resolution. The hurricane protection is not considered a material alteration, so you don't have to worry about that. There is a mechanism for the board to require the installation of the hurricane protection. The board, with the approval of the majority interests of the condominium association, can install or require that unit owners install the protection that exceeds, that complies with or exceeds the applicable building code. But however, there are exceptions for those who already have hurricane protection that meets that applicable building code. There are provisions dealing with repairs and maintenance when the hurricane protection is the responsibility of the association as compared against the unit owner. There is provisions for allowing the association to operate the hurricane protection under certain circumstances. And there's some caveats that the board cannot refuse to approve installation or replacement of hurricane protection so long as it conforms to the specifications adopted by the board. But however, the board can also require owners to adhere to a unified building scheme regarding the external appearance of the building. A unit owner, there's some interesting internal disputes within the legislation itself when the unit owner is, where it says in the new legislation, the unit owner is not responsible for the cost of removal or reinstallation of hurricane protection if removal is necessary for maintenance, repair, replacement. But that's not the end all save all, because in the existing legislation, it says 180 degrees the opposite. I don't cover that here. I'll probably write about it and publish about it soon, but I am informed the legislators in Tallahassee are aware of that little snafu and will fix it in this coming year's legislation, something for all of us to look forward to. And there's all kinds of additional information, but in the interest of time, we have to keep going. The statute of repose, that's the outside date by which you may bring a cause of action. So even if you're within the statute of limitations, the statute, you must also comply with the statute of repose. Let's say your statute of limitations is 4 years from the time you knew or should have known of a problem, but the temporary certificate of occupancy for the project was issued at least 7 years ago. Well, if that 7 years has transpired, even though you just discovered the problem and timely filed your lawsuit within the statute of limitations, the statute of repose could prevent you from bringing that lawsuit. So let's make it real for a minute. Condominium association is taken out of the ground. Sales are slow. It takes the developer 7 years before he turns the association over to unit owner control. The diligent board goes ahead and hires the engineer, and they find defects and they file their lawsuit. Well, because of last year's law, that lawsuit would be time barred because greater than 7 years passed from the issuance of the temporary CO the developer received, allowing people to move in, even though that lawsuit was brought within the statute of limitations, but it was brought outside the statute of repose. Big problem if you turned over in a condo last year. Legislature fixed that this year. Now the statute of repose, like the statute of limitations for a condominium association, begins to run at turnover, the day the unit owners take control. Yay, great consumer legislative fix. Essentially, we're going to move on to SLAP suits. And condominium associations are now being restrained from filing lawsuits against owners in the nature of a retaliatory lawsuit for things like tortious interference and nuisance even, and things. You cannot bring these claims. It's like a retaliatory conduct prohibition, unless we can show, you can show, that the owner themselves was not acting in good faith. So if an owner is acting in good faith and they complain to local government, the owner is acting in good faith and they file a lawsuit against the association is prohibited from filing certain counterclaims and taking certain actions against that owner unless the owner was acting in bad faith. And that's enough. The outline will cover more of that for you. if you're in that courtroom situation and the owner has filed his lawsuit, the association then files a defamation lawsuit, tortious interference, and the owner says, hey, that's retaliatory, that's a slap suit, you can't do it. Well, that issue will then go to the top of the judge's calendar and get resolved before the litigation continues. We have clarification that a director who asserts they have a conflict of interest, they still count towards the quorum at the board meeting. If you're going to suspend an owner's right to vote, you have to do that at least 90 days prior to when that vote is going to take place. So let's say they're delinquent in monetary obligation assessment, you suspend them for so they can't vote, but that has to be done long in advance, at least 90 days. The division of condominium has significant expanded jurisdiction on all sorts of matters that they didn't have before. Alan alluded to one of them before, the official records and keeping them, quote unquote, organized, procedural aspects and records related to financial issues, including annual financial reporting, assessments, fines, operating funds, use of debit cards, the prohibition. There's no prohibition I'm aware of on credit cards. It's only a prohibition on debit cards. They have all sorts of jurisdiction for elections, disclosure of conflict of interest, not completing the structural integrity reserve study, and more. The division and the ombudsman have a right to attend board meetings and membership meetings. And finally, that brings us to the Corporate Transparency Act. Corporate Transparency Act is actually from the United States Department of Treasury, the FinCEN agency within the U.S. Department of Treasury. And they have decided that any corporation, with a few exceptions, and sadly, community associations are not in the exceptions, any corporation, including a community association, that registers with the Department of, with your division of corporations in your local state. So here, you go to Sunbiz to update the board of directors, right? That's the Department of Florida Corporations. You now have a requirement with FinCEN, and you have to provide the name and the address and a piece of identifying information, which I'll talk about in a minute, of all the beneficial owners of the company. Well, in our case, who are the beneficial owners? You keep reading the legislation. The beneficial owners are the folks that are making the decisions. So obviously your board members and officers, they're making the decisions. Managers could get caught in a trap because if for some reason managers have the ability to make decisions, there's an argument there that they're a beneficial owner too. So watch out for that. And when you provide this information, the name and the address, you also have to provide a copy of a driver's license or other state governmental issued ID. So you're a police officer, you're on the board, you've gone to great lengths to keep your name and address out of the public records. There's no exception for you. There was a court case, Small Business Administration challenged the law, and the judge found the law unconstitutional. Sadly, he only held it in favor of those individuals involved in the legislation, 27,000 small businesses in another state, and sadly, therefore, the rest of us still have to comply. Now, what's interesting is I think this law is really subject to a huge challenge. We had the Chevron decision overturned by the United States Supreme Court just the other day. It's very exciting. We all elect our legislators to the United States Congress to make the laws by which we live. Well, in the past, the legislators would then create agencies and give the power to the agencies to create rules. These rules are in the Code of Federal Regulation, and they are equally enforceable as if Congress passed the law themselves. And this is why we have these very liberal assistance animal, right? Jeff is depressed. It affects them at work. Having the animal at home makes Jeff more productive. I get my assistance animal in the no pet community. Doggone it, I'm a huge dog lover. Don't take this the wrong way. I've always had dogs, always will. But if you move into a no pet community, doggone it, pun unintended, you ought to be able to live in a no pet community because that was your choice. Here, the federal legislation is telling you, you got to do this. You have to let the dog in because you met the basic requirement. Congress didn't pass that law. A group of guys in a small room assigned by Congress within the Federal Housing Authority said, yeah, we're going to make sure everybody can have a dog. And that's what they did. But that was such an overreach. The Chevron case allowed all that to happen. It allowed the agency power. That case just got flipped upside down. It was a fisherman, and Congress decided that, not Congress, but the EPA decided that if you're this kind of fishing boat, fishing for this kind of fish, you had to allow one of their people on board the entire time and take care of them and couldn't leave without them. And you got to pay for him to be there, the inspector, the whole thing. And they said it was just so much of an overreach. And the Supreme Court agreed with them and overturned the Chevron decision, which is going to reel back the power of an agency. So all of a sudden, I think we're going to, the only reason I bring this up is because of the assistance animal issue. And it is now a fully ripe environment for some brave condo or HOA that wants to be no pet to challenge that law. It's out there, it's available. Someone needs to challenge the Federal Fair Housing Administration's liberal governance, which requires no pet communities to have the emotional support animal. I'm only talking about emotional support here. I am not talking about any particular animal that is necessary as a service animal for blind, for hearing, for diabetics, for seizures, and so many other important things. I think those people should always be allowed their animals, but I think the emotional support animal in the no pet community is probably going too far, and it's ripe for challenge. So I just wanted to bring that up as a lucky strike extra for you remaining several hundred people still out there. Gosh, it's been fun, everybody.
Hey, Jeff, I got something for you. We were both right. I looked up the quarterly meeting issue.
Oh.
So the statute does two things in condos. In a residential condo of more than 10 units, the board must meet at least once a quarter. That's your correct part. At least 4 times each year, the meeting agenda must include an opportunity for members to ask questions of the board. That's my correct part. So you do have to have at least quarterly meetings, but if you're doing it more than quarterly, again, like I said, I don't see a problem allowing people to ask questions every, once a month for 4 straight months. I don't think that was the intent of the legislation, but there's nothing that prohibits it.
You know what's funny about the members' right to speak at the meeting? Great. The legislature, a few years ago, members have a right to speak on all items on the agenda. Okay, great. Now legislature says you have the right to ask questions. Great. There's still no obligation to answer.
Correct.
Wow, we covered a lot of ground today, everybody. Sorry we couldn't get to everybody's questions. We're already running over. Y'all are nice to stay with us. Courtney, Alan, you guys are amazing. Jeff, thank you. Jeff Solomon, thank you. We're here, so I don't know what else to say other than have a great weekend.
Thank you guys so much. For anybody that I answered your questions, I am not an attorney, so take them with a grain of salt. I did follow most of what was written in the guide that was provided in the chat, so I think my answers are pretty good, but like I said, anything that you're not sure of, definitely reach out to your association manager. Kaye Bender Rembaum is a great resource. They have a lot of resources and previously recorded webinars on their website. That's kbrlegal.com. I really appreciate you guys for hosting this today or presenting this today. A lot of people in the chat said it was great resources. They really appreciate it. I apologize for anybody's questions we did not get to. Feel free to email me with those questions. I know the guys are going to have their emails posted as well. And I think, thank you everyone, and have a great rest of your Friday and a great weekend.
Bye-bye.
Again,
remember, the advice we gave today is not specific to your association. Check with your lawyer regarding how it applies to your association. We're talking about these new laws in a general sense.